Hi, my name is Adam Juratovac, and I'm a California employment lawyer located right here in San Jose, California. I work at Juratovac Law, and our firm focuses on civil litigation, employment litigation, and business law. And today our firm just filed a civil lawsuit in Santa Clara County Superior Court on behalf of one of our clients. Now, when you file a civil court complaint, that means there's typically a plaintiff who's making certain allegations of what occurred, and those allegations are typically violations of the law. Now, this particular case is an employment law case, and what I'm about to read right now was just filed in Santa Clara County Superior Court on November 2nd, 2021. Now, one thing I want to make very clear is when we're looking at a court complaint, this is typically just one side's allegations, which means, and you have a plaintiff, and when you file that court complaint, this is what that plaintiff asserts and alleges to be true. Now, you have to remember, this is only one side of the story, so there's always going to be another side of the story when it comes to the defendant in the case, or in this case, multiple defendants. What I'm about to read is a publicly filed document that lists the allegations that Ms. Muñoz alleges with regard to her previous employment. So let's jump into it. Filed in the Superior Court of California, County of Santa Clara, unlimited jurisdiction. Natalia Muñoz, plaintiff, versus Dr. Dean Lee, Fook v. Lee Optometry Incorporation, DBA IC Optometry, and DOEs 1 through 10 inclusive. The complaint is for damages, and Ms. Muñoz alleges 12 violations of California law. The first violation is a Fair Employment and Housing Act violation for discrimination. The second violation is a FEHA violation for harassment. The third cause of action is a FEHA violation for failure to prevent discrimination and harassment. The fourth violation is a FEHA violation for retaliation. The fifth cause of action is negligence. The sixth cause of action is negligence. The seventh cause of action is intentional infliction of emotional distress. The eighth cause of action is assault, battery, and sexual battery. The ninth cause of action is failure to pay minimum wages. The 10th cause of action is failure to provide duty-free meal periods and rest breaks. The 11th cause of action is failure to provide proper pay stubs. And the 12th cause of action is constructive discharge. Plaintiff Natalia Muñoz alleges as follows. Jurisdiction, venue, and parties. Plaintiff Natalia Muñoz, at all times relevant, is a resident and worked in Santa Clara County, California. Defendant Dr. Fook Dean Lee, Dr. Lee, is a California optometrist, license number 12744T, owner of Fook v. Lee Optometry Incorporation, DBA IC Optometry, and he's a California resident. Defendant Fook v. Lee Incorporation, DBA IC Optometry, is and at all times relevant times have been a business formed within the state of California, located at 6815 Camino Arroyo, Suite 60, Gilroy, California. Muñoz was employed by IC Optometry at all times relevant to this dispute. Plaintiff does not know the true names or capacities, whether individual, corporate, associate, or otherwise, of defendants sued herein as DOEs 1 through 10 inclusive. Plaintiff sues said defendants by such fictitious names and will seek leave to amend this complaint when the true names and capacities of said defendants have been ascertained. Jurisdiction and venue are proper because a substantial portion of the acts giving rise to defendant's liability occurred in the County of Santa Clara, California. The amount in controversy herein exceeds $25,000, and thus this matter is properly designated within the jurisdiction of this court. Now we're moving to the general allegations. Muñoz is a 20-year-old college student. On February 20th, 2020, Muñoz interviewed with IC Optometry for a position as optician. IC Optometry hired Muñoz on that date and agreed to pay her $12 per hour. Muñoz began working on February 23rd, 2020. During Muñoz's orientation, Miss Medina, IC Optometry office manager told her, "We don't have paid rest breaks here. We only provide employees a 1-hour unpaid lunch." Miss Medina told Muñoz, "If you want paid rest breaks, you will have to sacrifice your lunch period." IC Optometry, Miss Medina, and Dr. Lee restricted Muñoz from taking rest breaks. Miss Medina required Muñoz work through any rest break period she was entitled to. For the duration of Muñoz's employment, she was not allowed to take a bona fide rest break period. Ms. Medina also made it clear that she was the office manager, that she had managerial control over workers, and she had full authority to implement any policies and procedures needed to operate the business and supervise the employees. She made clear to Muñoz that Ms. Medina was second in command, below Dr. Lee, and she was the person with the authority to oversee and manage employees. Ms. Medina intentionally failed to provide the required notices Muñoz with respect to protection from illegal harassment. Ms. Medina intentionally failed to recommend the establishment of a sexual harassment policy, failed to recommend training of supervisors and subordinates on the subject of sexual harassment, and failed to acquire any materials for herself or managers at the office, an oversight of their corporate sexual harassment policies. Ms. Medina likewise intentionally failed to notify Dr. Lee about his requirements to comply with the sexual harassment laws and regulations. In like manner, Dr. Lee intentionally failed to undertake each of the responsibilities also required of Ms. Medina in IC optometry. Dr. Lee thus intentionally failed to provide posters, notices, policies, training, materials, and compliance instructions to his staff on the topic of sexual harassment. Dr. Lee further intentionally failed to obtain training and education for himself on the topic of sexual harassment, and he failed to pass that training onward towards members of his staff. IC Optometry tracked employees' unpaid lunch breaks through a time tracking machine. IC Optometry required Muñoz to clock in and clock out daily by using the time tracking machine system, which was activated via thumbprint. The time tracking machine resided in the employee break room. The time tracking system will prove IC Optometry prevented Muñoz from taking a bona fide rest period during her employment. IC Optometry typically required Muñoz work 5 days per week. She arrived at work at around 9:30 a.m. and typically did not leave work until at least 7:30 p.m., sometimes 8 p.m. Muñoz worked days at IC Optometry that she was not paid. On at least one day, Dr. Lee instructed Muñoz not to clock in while working at IC Optometry. IC Optometry required Muñoz to use her personal cellular phone for work purposes in order to take work calls, create work newsletters, and receive messages from IC Optometry staff. IC Optometry did not reimburse Muñoz for her work-related uses of her personal cellular phone. IC Optometry's premises are monitored by several video surveillance cameras. Dr. Lee had access to IC Optometry's live video surveillance camera footage via his personal cellular phone and his personal computer. Dr. Lee repeatedly and frequently watched the surveillance footage of the IC Optometry employees on his devices. Since this video surveillance maintained records of hours worked and job duties performed, defendants were required to keep the video surveillance record for a period of at least 3 years. Defendants destroyed either intentionally or negligently these videos of hours recorded, worked, and job duties performed. In one instance, Muñoz searched for an ultraviolet lamp to disinfect glass lenses. As she searched under tables for the lamp, Muñoz was bent over at the waist for an extended period of time. Eventually, she called Dr. Lee to ask where he had put the lamp. Dr. Lee responded with, "I have been watching you on the surveillance cameras," meaning he had been watching her body while it was bent over and searching under tables. Dr. Lee's comment made Muñoz feel irritable and uncomfortable. On June 15, 2020, Dr. Lee handed Muñoz and her coworker a marijuana-laced chocolate bar, a marijuana-laced lollipop, and a marijuana-concentrated oil cartridge. Dr. Lee's language implied the workers should have been happy. He was providing this fringe benefit to them. IC Optometry's reception space connects to the break room via a 25-foot hallway with no windows or doors. Dr. Lee's private office is located approximately halfway down the hallway. Throughout Muñoz's 6 months of employment, Dr. Lee regularly followed her as she walked from the reception space to the break room, i.e. at least once per day. Muñoz noticed that Dr. Lee was both following her and viewing her body from behind, and his daily habits made Muñoz feel very uncomfortable. On July 25, 2020 at around 4:30 p.m., Muñoz began organizing and cleaning her desk in the reception area. She was using Dust Off, a compressed aerosol duster to clean both her desk and her computer keyboard. Dr. Lee came to Muñoz and said, "Oh, I've been looking for the Dust Off. I didn't know you had it." Muñoz told Dr. Lee that she had put the Dust Off device behind the printer. After cleaning her desk, Muñoz walked down the long hallway to the back room to clean lenses. As she walked down the hallway, she again noticed Dr. Lee was following her from behind. Muñoz arrived at the break room and walked to the ultraviolet lamp, which was stored under a desk. She squatted down, picked up the ultraviolet lamp, and put a tray of lenses underneath the lamp. Still squatting, Muñoz turned on the lamp to disinfect the tray of lenses. As Muñoz started to raise out of her squatting position, she felt an impact on her left buttocks, followed by a strong burning sensation. The impact lasted at least 5 seconds. Muñoz yelled out from pain and jumped up in shock. When she turned around, she saw Dr. Lee standing over her with the dust-off aerosol spray in his hand, grinning from ear to ear. She then realized Dr. Lee had sprayed the dust off directly onto the center of her left buttocks while she was bent over. While Muñoz was standing in shock and rubbing her left buttocks, Dr. Lee stood and laughed at her. He then gleefully exploded with, "I got you, I got you." When Muñoz said, "It's starting to hurt," Dr. Lee responded with, "Yes, the spray will probably hurt you." When activated for extended periods of time, the dust-off aerosol spray reaches sub-freezing temperature as low as minus 60 degrees Fahrenheit. Muñoz stormed out and rushed towards the front reception desk. Dr. Lee chased her and followed her down the hallway. A colleague, Monica Martinez, happened to exit a nearby bathroom and asked Muñoz, "What happened? I heard you scream." Muñoz told Miss Martinez, "Dr. Lee just sprayed me." With her left buttocks hurting the rest of the day, Muñoz sat gingerly in her chair but finished her day of work before going home. By the time Muñoz arrived at home, her left buttocks was throbbing, discolored and swollen. She checked her buttocks in a mirror and she was shocked to see a bruise greater than the size of a $50 coin on the area Dr. Lee had sprayed. Muñoz's bruise was multiple shades of purple and pink, and it continued to be sore and tender throughout the night. The next day, July 26, 2020, Muñoz told Miss Medina about Dr. Lee approaching her from behind, looking at her buttocks, and then spraying buttocks with the dust off. Muñoz told Miss Medina that she felt degraded, and Dr. Lee had sexual intent when he sprayed Miss Muñoz, and that he had left a serious bruise on her buttocks. Miss Medina said that she was shocked to hear what happened, and she volunteered to speak with Dr. Lee about what he had done to Miss Muñoz. Later that same day, after Miss Muñoz had reported the sexual battery, Miss Medina came to her and announced, "You will be switching positions from an optician to a front desk receptionist." When Muñoz asked why she was required to change jobs, Miss Medina said, "Dr. Lee does not think you deserve to be an optician. You don't want to be an optician as bad as your coworker Monica does. Dr. Lee wants you to increase your work performance." Muñoz was shocked by the obvious demotion, which equaled retaliation, and considered the demotion to be an additional form of both retaliation and harassment, since Dr. Lee had never mentioned the demotion before he sexually battered Miss Muñoz. Muñoz was equally offended by the fact that Miss Medina at no time offered to conduct a full investigation of the battery event, asked what Miss Muñoz wanted as a remedy for the sexual battery, or offered to protect Muñoz from further harassment or battery at work. Muñoz considered Miss Medina's actions and inactions to be additional forms of harassment against her as a female. Before Dr. Lee put the demotion into effect, and while Muñoz was still an optician, Dr. Lee dramatically decreased the number of patients assigned to her. As just one example, on July 27, 2020, Dr. Lee only assigned 2 patients to Muñoz. By contrast, Dr. Lee assigned her coworker more than 5 patients that day. Dr. Lee also began shunning Muñoz after she reported and complained about his sexual battery at work. As just one example, on July 27, 2020, Dr. Lee hosted a team building event in the back room with his staff. Dr. Lee provided the staff with alcoholic beverages, and Dr. Lee never invited Muñoz into the event. On July 27, 2020, realizing she was being shunned, Muñoz told Medina, "I feel uncomfortable working here. I can't work under this type of anxiety. I reported sexual harassment yesterday and nothing happened. I don't think you're taking my complaint seriously. Because you're not taking me seriously, I'm going to be leaving you guys." Miss Medina responded with, "I'm sorry you feel that way. I spoke to Dr. Lee and he said he was just joking around with you." Again, Miss Medina made no commitments regarding a full investigation of the battery event, did not ask what Muñoz wanted as a remedy for the sexual battery, or offer to protect Muñoz from further harassment, battery, or retaliation at work. When no assurances arrived from the office manager, Muñoz was appalled by the total non-response to her sexual harassment battery complaint, handed Miss Medina her keys to the office, and left. Over the next week, Miss Medina never reached out to Muñoz to offer a full investigation, asked Muñoz ideas for a remedy, or offered to protect Muñoz from further harassment, battery, or retaliation at work if Muñoz returned. By August 4th, 2020, Muñoz's wound on her left buttocks had nearly doubled in size, continued hurting 24 hours a day, and Muñoz was using moisturizing lotion onto the injury site at least twice per day. On or about August 9th, 2021, Muñoz filed timely administrative complaints against all defendants under the Fair Employment and Housing Act. She filed complaints of discrimination, harassment, and retaliation among the various complaints. Muñoz has requested her right to sue letters from the Department of Fair Employment and Housing, and she timely brings this complaint in this superior court. Muñoz served her Fair Employment and Housing Act complaints to defendants via certified mail. Accordingly, Muñoz has properly and timely exhausted all administrative remedies required under the Fair Employment and Housing Act. The first cause of action that Ms. Muñoz is alleging is discrimination under the FEHA as against IC Optometry. The second cause of action that Ms. Muñoz is alleging is for harassment under the FEHA as against all defendants. The third cause of action that Ms. Muñoz is alleging is failure to prevent another FEHA violation as against IC Optometry. The fourth cause of action that Ms. Muñoz is alleging is for retaliation under the FEHA as against IC Optometry. The fifth cause of action that Ms. Muñoz is alleging is for negligence as against IC Optometry. The sixth cause of action that Ms. Muñoz is alleging is for negligence as against Dr. Dean Lee. The seventh cause of action that Ms. Muñoz is alleging is for intentional infliction of emotional distress as against all defendants. The eighth cause of action that Ms. Muñoz is alleging is for assault, battery, and sexual battery as against Dr. Lee. The ninth cause of action that Ms. Muñoz alleges is for failure to pay minimum wages as against IC Optometry and Dr. Lee. The 10th cause of action that Ms. Muñoz alleges is for failure to provide rest breaks as against IC Optometry. The 11th cause of action Ms. Muñoz alleges is for failure to provide proper pay stubs as against IC Optometry. The 12th cause of action Ms. Muñoz alleges in this complaint is for constructive discharge as against IC Optometry. In this complaint that I filed on behalf of Ms. Muñoz in Santa Clara County Superior Court, Ms. Muñoz also requests a jury trial. And as discussed at the beginning of the video, this is Ms. Muñoz's side of the story. This is how she alleges her employment occurred. There's always another side of the story, but what I'm sharing with you is what my client alleges. Now, thank you for tuning in. My name is Adam Juratovac, and I'm an employment lawyer at Juratovac Law in San Jose, California. And remember, conoce tus derechos. Know your rights. Thank you.